Good morning, everyone. Well, it looks like it's time for us to begin an oral argument session of the 5th District Court of Appeal. Welcome to the court, at least in a virtual sense. I'm Judge Orfinger. I'm joined today on the panel by Judge James Edwards, and we're pleased to have an associate judge with us, Melanie Chase. Welcome to the court. This is being recorded and broadcast on YouTube. Not sure that we'll get as many hits as some of the other viral videos get, but we'll see. First case we have this morning is Christopher Botto versus the state of Florida. Both sides have 20 minutes. If the appellant would like to reserve something other than 5 minutes, the clock is preset at 5, but if you want something other than that, let us know, and we'll try to keep track of that for you. Can you both see the clock on the screen?
Yes, Your Honor.
Yes, Your Honor.
Okay, good. All right, Mr. Ufferman, you may proceed.
Thank you. Good morning. May it please the court. Michael Ufferman on behalf of the appellant, and I would like to reserve 5 minutes of my time for rebuttal. I'm hoping to focus my time this morning on one of the claims that was denied following an evidentiary hearing and two of the claims that were summarily denied. Let me begin with the evidentiary hearing claim. And that is the claim that defense counsel was ineffective for failing to object to uncharged conduct. Now, I don't think there's any dispute in the record. I don't think either the state below or on appeal disputes that the information in this case, which is page 25 of the record, does not allege that this offense involved oral sex. And during the first trial, there were two trials in this case. The first trial ended in a mistrial in December of 2012. My client was convicted following a second trial. But during the first trial, the judge had ruled that the state would not be permitted to introduce any evidence of uncharged conduct. However, during the second trial, the state introduced a CPT recording. And during that recording or interview, the alleged victim claimed that my client engaged in oral sex. And defense counsel, either prior to trial or during the trial, took no steps to object or request that that reference to oral sex be redacted out. And to her credit, during the evidentiary hearing, defense counsel conceded that she failed to object to the uncharged conduct, and she had no strategy reason for failing to do so. So I think there's no dispute that the first prong of Strickland is established. Defense counsel was ineffective for failing to object. And in fact, I've cited this in my briefs on page 965, defense counsel actually filed a motion for new trial following the trial and argued that one of the errors was that there was the introduction of uncharged conduct. But of course, that motion for new trial was denied because defense counsel had not timely objected during the trial. So the only question is whether or not my client was prejudiced under the second prong of Strickland. And the post-conviction court denied this claim, saying that my client was not. But as I've argued in my briefs, I submit that my client was prejudiced by the introduction of uncharged conduct in this case. I've cited the Pastor case, which is one of many Florida cases that's held that the improper admission of collateral act evidence is presumed to be harmful error. And the reasons the courts reached that conclusion is that uncharged conduct has the undue tendency to suggest a decision on an improper basis. It inflames the jury, or it appeals improperly to the jury's emotions.
Counsel, how do we determine when a defendant has been prejudiced enough to deserve a new trial? I mean, as you cite in your brief, anytime uncharged crimes are mentioned, that's presumed harmful. But on the other hand, there are a lot of cases that discuss when something does not become a feature of the trial versus when it does. So where do we draw the line here?
And that's the tough part of the Strickland standard. In any case, it's usually pretty easy to determine if counsel was ineffective or not. Trying to determine whether the prejudice prong has been met is more difficult. I think there's a couple things to look to. The state notes that the state didn't cite the uncharged conduct during closing argument, but defense counsel herself did. So that even adds to the ineffectiveness, adds to the prejudice that she's the one that highlighted the uncharged conduct during closing arguments. Beyond that, I submit this was a closed case. The allegations occurred during a 2-week trip that the alleged victim visited his grandfather in the summer of 2012. During that 2-week trip, The alleged victim had contact with his parents every night by phone. He never once claimed during any of those phone conversations that misconduct was occurring. The alleged victim actually had the ability, and the testimony is clear in this in the record, to choose where he wanted to sleep. There was two houses next to each other, his great-grandmother's house and his grandfather's house. My client lived with the grandfather, and the alleged victim said that he initially slept with the great-grandmother's house. He wanted to go home if he had to continue to sleep there. He chose to stay at his grandfather's house and could have gone back to his great-grandmother's house at any time. And then the final thing I would point to is that this whole allegation came about the weekend after the alleged victim came home, where the mother asked a very leading and suggestive question about whether or not my client had touched him improperly. So I think it is a close case, and the closer the case, the fact that it was highlighted by defense counsel herself in closing argument, and the fact that there are numerous cases that find that this is one category of evidence that is presumed to be harmful, would establish that the evidence in this case was in fact prejudicial, and that this court should reverse for a new trial.
Let me ask you a related question. There was a Williams Rule witness who testified about supposed molestation at the hands of appellant, and his testimony included discussion of oral sex as well, did it not?
I think it did, and that's another reason why if this case doesn't involve any allegation of oral sex, but now the jury is hearing about a Williams Rule witness, and that Williams Rule witness does bring up oral sex, for all the reasons that I talked about, it inflames the passions of the jury. If the jury is thinking, hey, here's even additional evidence that the state didn't charge him with. And again, we know my client has a due process right to only be charged and convicted of what was alleged in the information, and yet there's more evidence coming out about uncharged conduct in this case. I think that's another reason why it would be prejudicial in this case. Let me shift to, and of course, so again, I'd ask the court to reverse for a new trial on that. Let me shift and address two of the claims that were denied without an evidentiary hearing. The first one I want to address is the mistrial claim. And as I explained earlier, this case proceeded to trial in December of 2012 initially, and this was a speedy trial case. The allegations came about in the summer of 2012, and my client invoked his right to a speedy trial, and therefore the trial was initially scheduled in December of 2012. And the record is clear that the state was not ready to proceed to trial. They indicated that they had other matters that they were attending to. They actually filed a motion to continue that was denied by the judge, and this case proceeded to trial. And at that trial, the state presented the testimony of the alleged victim's grandfather. And during his testimony, he made a vague reference to my client's past. The record shows that immediately defense counsel objected, the parties went to sidebar, and defense counsel requested a mistrial. The trial judge directed defense counsel to discuss that with my client, and notably, that discussion is not on the record. And that's key for this context. It's a summary denial case. The only way it can be denied without a hearing is if the record conclusively refutes the claim. There is no record of the discussion between defense counsel and my client. Shortly after that discussion, defense counsel comes back on the record and says, we want a mistrial. She basically says there's no other option, and the trial court grants the mistrial. In his 3.850 motion, Mr. Botto alleged that during that brief discussion with defense counsel did not explain that there was other options other than a mistrial, whether it be a curative instruction or simply moving past the vague reference and moving on, because as the prosecutor argued at the time of the motion for mistrial, this was a very benign reference. There's no allegation of an arrest or any prior sexual misconduct. We don't even know what he meant by past. He didn't even specifically say that there was a past. I said one option was simply to move on.
Counsel, assuming all that is correct, how do you demonstrate that he was prejudiced by the mistrial?
And that's the most important aspect of this claim, Your Honor. In many cases, prejudice may be difficult to establish, but in this case, there's two very important reasons why the record would certainly infer prejudice. And again, at this stage, we haven't even had a hearing. But what my client alleged in his motion is there's two things that were not discussed with him that would be required to be discussed in order for him to knowing, intelligently, and voluntarily waive the trial and the constitutional right to that jury that he had and accept the mistrial. Number one is child hearsay. I've handled dozens of these types of cases, and in every single case, the state tries to introduce child hearsay testimony. Usually they try to introduce the child hearsay testimony through the CPT interviewer and the recording of the CPT tape, which ultimately did happen in this case during the second trial. The reason that's so beneficial to the state, as the court well knows, in a case involving an alleged adult victim, that type of hearsay is never admissible. And the reason is because it improperly bolsters the alleged victim's testimony. You can't have the alleged victim testify in the stand and then hear from a police officer, a nurse, and then the alleged victim's best friend, because the jury gets to hear it over and over again. But the legislature has said that when cases involving child victims, we're going to make an exception and allow in child hearsay if certain criteria is met. And in almost all of these cases, the CPT interview testifies, the CPT tape is played for the jury, and then other people also testify about child hearsay statements that they heard. That happened in this case through the mother as well. That's extremely powerful for the state, because not only do they get to hear the alleged victim on the stand, but they get to hear a somewhat contemporaneous version through the CPT interview, and actually get to hear the recording itself, and they got to hear the mother make the child hearsay allegations. The state in this case had not filed a child hearsay notice prior to the first trial. That means at that first trial, no child hearsay was going to be heard by that jury. Again, usually extremely beneficial for the state, but would not have happened. The only way my client can make an informed decision about whether to accept a mistrial or reject the mistrial option is if defense counsel would have explained that you need to understand, if we take a mistrial, that's going to reset the clock, and the state will have the ability to timely file a child hearsay notice prior to the next trial, which is exactly what they did. The second piece of evidence that was extremely important was the Williams rule evidence. It's already been referenced in this oral argument. The state, when it moved for a continuance, specifically said it was having problems with its Williams rule witnesses. Again, Williams rule witnesses can be extremely powerful for the state. And it sounds, based on this record, and we don't know because we haven't heard from defense counsel, that there was a good probability that the state was not going to be able to present one or even both of the Williams rule witnesses. So,
Counsel, I have a question for you there. On page 17 of your brief, you talk about the fact that the mistrial allowed the state to get Williams rule witness JV to testify. However, on page 22 of your brief, you complain that during the grandfather's testimony, that same witness JV violated the rule of sequestration because he was sitting in the courtroom. Now, you can't have it both ways, that he was not there on page 17 and he was there on page 22. And I would ask for you to clear this all up for me.
well, I think the only way you can clear it up is to have a hearing, Your Honor. So at this stage of the proceedings,
no, I'm asking you to clear it up. You're saying on page 17 that your client was prejudiced because JV was not there. On page 22 of your brief, you're claiming your client was prejudiced because he was there. Now, he can't both be there and not be there. You have to take a stand, I think, don't you?
Well, I would submit that I don't, but I will say this. The evidence shows from the first trial, after the first trial, there were hearings on a motion to dismiss with prejudice. And it was established that JV was not under subpoena and in fact had not even made contact with the state attorney's office until February of that year. So it could be that the state wasn't even aware of JV, had never made contact with JV. JV, for whatever reason, still decided to come to the trial knowing that it was going on and listened in. My client believes that he saw that. We haven't had an evidentiary hearing to get to the bottom of that. And again, there's no way that can be resolved without actually hearing evidence relating to that and getting to the bottom of that claim. Now, I'm not going to be focusing on that aspect, the whole whether JV was there, because again, I think the record is crystal clear that the state had not even made contact with JV. JV was not under subpoena, and JV would not have been available as a state witness during the first trial. So again, it comes down to my client has the right to either choose the mistrial or not. I've cited to the Middleton case where the first DCA specifically reversed because they said the option of a mistrial is something that only the defendant can choose. And unless it's properly explained to a defendant, then a defendant would be denied the right to effective assistance of counsel. In this case, if defense counsel did not properly explain to my client the other options other than a mistrial, and not properly explain that generally a mistrial may be a good thing, but there's disadvantages. Number one, you lose this jury who you may like right now. Number two, and perhaps by far more importantly, if we ask for a mistrial, it resets the clock. It gives the state more time to find its Williams rule witnesses. And far more importantly, it gives the state the opportunity to introduce child hearsay at the second trial, which in fact they did. And again, there's case after case that's released on a weekly basis talking about how difficult, how beneficial child hearsay can be to the state in these types of cases. That's something that if it wasn't explained to my client, there's no way any decision he would have made about whether to proceed with the mistrial would be knowing, intelligent, and voluntary. And again, we don't have a record of that in this case.
Did you allege in your motions or arguments to the trial court or in your brief the claim that the child hearsay would not be available?
Yes, it is specifically alleged in the brief. If you give me a moment, Your Honor.
Why don't you just tell me on rebuttal? I don't want to throw you off here. Just tell me when you come back on rebuttal the page. That's fine.
Okay. So then I'm looking at it right now. It's on pages 16 and 17. The mistrial allowed the state to timely file for and gain admittance of hearsay testimony of the second trial, particularly child protection team witness April McLaughlin and CJ.
Okay, thank you.
So on any given week in Florida Law Weekly, the most common reversal is for failing to hold an evidentiary hearing. And the reason is because the standard is very favorable for a defendant at this stage. If the record does not conclusively refute the claim, the defendant is entitled to an evidentiary hearing. This record doesn't say anything about this claim. In the post-conviction court's order, the post-conviction court stated that the record shows that defense counsel had a discussion with my client. The record does not show at all what they discussed. And if defense counsel failed to go over the disadvantages, failed to go over the other options, then clearly defense counsel would be ineffective. The only way this claim can be properly decided is if there's an evidentiary hearing, so the post-conviction court can hear from defense counsel, the post-conviction court can hear from my client. And after hearing all of that, the post-conviction court can make credibility determinations and ultimately rule on this issue and then determine whether or not there was prejudice. But at this stage of the proceedings, without any hearing, there's no way that this claim can be properly considered. Again, and I see I'm into my rebuttal, I'll take up another minute or so. If defense counsel gets up on the stand and says, I went over all of this with Mr. Botto and the trial court finds that credible, that would be the end of this claim. Conversely, if defense counsel gets up and says, I didn't discuss any of this, looking back, I really did need to go over the child hearsay possibility and the Williams rule possibility, and I failed to do all of that, then obviously this would be a very valid claim. There's no way this court can resolve that without a hearing. Let me quickly address the third claim I wanted to talk about, which is the failure to present an expert. During the CPT interview, the alleged victim said that he woke up with an erection, and it was at that point that the abuse was occurring. In closing argument, defense counsel said that yes, the alleged victim woke up with the erection, but there was no abuse that was occurring, and he was simply having a dream and imagining this. The prosecutor got up in rebuttal and said, wait a minute. That's unfathomable. That's the word the prosecutor used, that this alleged 8-year-old victim would have woken up with an erection. The claim in the 3.85 motion is it would have been easy for defense counsel to present an expert, a urologist, some other type of expert who would say, no, it's not unfathomable. It's actually very common for all males, including 8-year-old boys, to have erections while they're sleeping. And imagine how much stronger defense counsel's argument would have been. And clearly the state would not have been able to make that type of assertion during closing argument. I would note that the state in its answer brief actually says on page 13, appellant did not present or proffer any expert testimony so that a court could determine the value of the purported testimony. That's exactly the point. We want the opportunity to present the expert. That's what an evidentiary hearing is. We want to be able to put on the expert who would say that it is common, and only after that testimony is in fact presented at an evidentiary hearing can a court properly present or consider this claim. So I would ask the court to revert. Of course, I would ask the court to reverse for a new trial. Alternatively, regarding these two claims, I would ask the court to remand for an evidentiary hearing. I'll reserve my remaining 3 minutes for rebuttal. Thank you.
Thank you, counsel. Now we'll hear from the state.
May it please the court? Can the court hear me?
Yes.
Yes, good. Okay, because that hasn't been always the case at times. So I'll start with the last one first, if the court will allow. The penile tumescence is a common, I think that's how it's pronounced. It's a common thing. It's not something that the court found that an expert would have assisted anyone with. The argument that Mr. Ufferman is talking about when the state says it's unfathomable, if you read that argument in context, he was saying it was unfathomable for the child to wake up experiencing what he experienced, not wanting to wake up. And it wasn't a dream. It wasn't penile tumescence. And that was all it is. The record conclusively shows that. It's attached to the order, and the argument was that's not what happened. That's unfathomable. As to the mistrial, if we keep going backwards. The mistrial discussion went on for several pages of the record while the defendant was there. He understood what was going on. Then the judge said, take a break, talk to him. When they came back, counsel said, I've talked to him some more about it and have talked to him about prejudicial mistrial. The gambit here was obvious. That's what they're talking about. She asked the judge immediately for double jeopardy for prejudicial mistrial, that the state purposely did this because of all the reasons Mr. Ufferman just mentioned. They weren't ready for trial. They wanted to have their witnesses there, the Williams rule witness. So the defense felt very strongly they could get a prejudicial mistrial such that the state couldn't bring the charges again. This is evident from the fact there were motions to dismiss, motion for new trial, all citing this, that it was the state's fault. And this issue went up on appeal after that second trial. This court affirmed the conviction. The issue was they made a gambit. They had a gamble, and I'm sure she explained prejudicial possibilities of not having the state.
Counsel, you say you're sure, but without an evidentiary hearing, you know, your crystal ball, your reading of the tea leaves, whatever, versus the testimony of the defendant appellant and his trial counsel. I mean, it's not quite the same, is it?
No, it's not quite the same there, but this was on the trial record I was talking about. The defense attorney said, I explained to him about prejudicial mistrial, the prejudices involved with it, and made that requirement, a request to the judge immediately. We'd ask you to dismiss, or we'd ask you to have a mistrial and with prejudice so that the state can't bring it again. So that had to be discussed because it was discussed in open court down below. And I think that was the critical plan that was made. It was a strategic decision.
Counsel, again, if they'd been successful on that, obviously we wouldn't be here talking about the case.
Correct.
And that's not what appellant seems to be discussing. It's not whether or not the case could have been dismissed with prejudice. It's what are the other options? What are the other ramifications here? And those are things that, as he says and you say, and we all know, those weren't on the record because those were attorney-client communications, which typically aren't put on the record, correct?
Well, that's correct. We don't know, but we do know that she is a highly experienced attorney who took a break to discuss the merits of having a mistrial or not moving for mistrial. I will say secondarily that it didn't matter had they not moved for a mistrial. This judge, if you look at the record, and it's the main reason why this was denied summarily, this judge wasn't having any other result. The state begged and pleaded practically, saying, first of all, the language wasn't serious enough. It didn't say what kind of past he had, just said he had a past. Then they said we could develop other evidence. They went on, and the judge and defense counsel said, I don't think a curative instruction is going to work, but the state tried everything that they had to get the judge to not enter a mistrial, obviously.
But counsel, aren't you focused in the wrong place? The question is, was counsel deficient? He's alleged that she didn't explain the other options. If the record is accurate that the state didn't have its Williams rule witnesses available, and I think we all agree that is significant testimony in any case like this, isn't an evidentiary hearing required to find out exactly what she advised him of and how he made that decision?
I think the record at trial shows that maybe I am missing the point. The point is, what did she advise him? Did she?
Right. It isn't the point isn't what the judge wanted to do. The judge, I suspect, would not have just sua sponte granted a mistrial. She moved for a mistrial, and the judge said, you know, you better talk to your client about this. What we don't know, the missing piece here, is what that discussion was and to what extent she told him, for example, that if we get a mistrial, the state might not be able to retry it. If the state can retry it, they might get their Williams rule witness here. We don't know any of those things. Isn't that enough to at least suggest a hearing is necessary?
to suggest perhaps, but again, there's also got to be some prejudice here, and there is not. Had she won the mistrial, had they not done the mistrial, then she would have been accused of ineffective assistance for not having made the mistrial motion. I don't know what your relief is then too, because still, if you get a new trial, they got a new trial. But if you get a new trial, the evidence is still coming in.
Isn't the analysis though that this court is doing whether or not her failure to explain the options prejudiced him? So isn't it necessary that we have some sworn testimony from counsel as opposed to just argument during the trial? Don't we need to hear from her as to what she told him at the time?
That would be helpful, certainly, but I don't think it's necessary if you can't show that he was prejudiced in any way. And I don't know that you can speculate on the prejudice in this case. There was a mistrial, that motion was made. The state argued against it. The judge went ahead and granted it. Had that judge not granted it, what position are we left in? Had the judge not granted the mistrial and we went on through to trial?
Counsel for appellant pointed out two specific things that he views as prejudice. One was the state had not properly sought to introduce child hearsay testimony. And the second, which to me is a little bit iffy given the contradictory statements in their brief, of whether the Williams rule witness was or was not present. But talk about the child hearsay and the Williams rule briefly, as whether the fact that they got both of those in second time around and may not have the first time around.
Again, as the court found in this case, though, there was overwhelming evidence that if you want to talk about the child hearsay statement, if you want to talk about the oral sex, one point I would like to make is that this charge was lewd and lascivious. The jury had no knowledge that this was an uncharged crime. I believe I printed out the jury instructions, and all they have to prove is that the child was touched in a lewd or lascivious manner on the penis, and that's wicked, lustful, unchaste, etc. Doesn't say anything about the fact that oral sex or touching with the mouth is something uncharged in this. This was simply an L&L. So I don't think the evidence that came out about the oral had as much of an effect, especially when the defense attorney was able to argue. I mean, she said it repeatedly in her closing argument. It was watch the video 5 times, 10 times, 800 times. If you need to dissect it, it's the best evidence in this case that will prove this child had inconsistent statements and that the information was fed to him. So she mentioned the oral incident herself. The state never mentioned it.
Isn't the issue whether or not, wasn't the issue whether or not she was ineffective? I mean, doesn't that support the idea that her counsel was ineffective if she was mentioning uncharged crimes herself?
Well, I think that was part of the theory of defense, though, and she would have been remiss not to do that, especially after it came in. Whether it came in on purpose or not, she knew it came in, and she used that in her closing argument to her advantage. And it's a very well done closing argument. She points out many inconsistencies in a child's statement. The inconsistency, the oral statement or the oral sex is mentioned on the tape. Child did not mention it on the stand, nor could he have. And it was a clever play by the defense counsel. Again, she had over 100 jury trials. And I believe that the hearsay that came in didn't affect the outcome of the case. And I think that the evidence shows that, because the child, the CPT interview, the discussion with the mother, there is nothing really that rebuts that. The claim in here in the second issue that there was even some animosity was not proven in their hearing. When they called Kevin Jenkins to the stand, I think it was, he didn't testify there was any animosity. There was no other defense for the attorney to rely upon. It was just the best, the tape was the best theory of defense. They used the tape. They wanted the jury to review it. And I think it was a sound strategic decision, given that there was no other motive for this to be fabricated. I think that the evidence is clear from the record. If you look at it, they have the first trial, they have the second trial, and we have the hearing below. If there are no other questions, I would rely on my
Thank you,
brief.
Counsel.
Thank you.
All right, thank you. Mr. Ufferman, if you get the relief that you wanted, which is a new trial, isn't the same evidence going to come in?
I think that's an interesting question. And I think that's something that probably needs to be resolved by the post-conviction court first after hearing all the testimony. I think as an equitable remedy, Mr. Botto should be put back in the same position that he was in at the time of the error. And
Well, is there any law that would support that? I mean, I'm just trying to understand at the end of the day, the prejudice, and if you don't end up right back where you are.
Well, I think one opportunity, one option for a remedy in this case is that if the trial court finds, I think it's clear in the record, that the child hearsay was not going to be admissible during the first trial, the trial court would have to make some findings about what Williams rule witnesses would or would not have been available for the state at the first trial. And I think if there were to be a retrial, then one option as far as the remedy is concerned is for the trial court to say that Mr. Botto should be put back in the same position he was in at the time of the error. And that would
In
be
what
that
case, counsel, what case specifically do you rely on for that remedy?
I don't have a case to cite to, Your Honor. I do think principles of equity in this context would generally say that any person who's been aggrieved based on ineffectiveness should be put back in the same position. So an analogy I would draw is a plea offer. When the cases say, Lafler from the US Supreme Court, similar case from the Florida Supreme Court, Alcorn, I'm sorry, when a defense counsel is ineffective about failing to advise a defendant about a plea offer, then even though the defendant's gone to trial and lost and been sentenced to a much greater term after the trial, the defendant should be given the benefit of the plea offer that he was not afforded because of defense counsel's ineffectiveness. That same type of equitable principle should apply here. If the state was not going to have the benefit of the child hearsay during the first trial, and if the trial court finds that defense counsel was ineffective for failing to go over the disadvantages of actually going through with the mistrial, and this would mean that the state would get the benefit of child hearsay the second time around, would get the benefit of one or both Williams rule witnesses, then Mr. Botto should be put back in the same position he was in, and there should be a trial, a second trial, where the state doesn't get the advantage of the child hearsay. So I would suggest that's one option for a remedy in this case. But I think this is something for the trial court to consider in the first instance at the trial court level. As the court has said, made clear from its questions, I think it is clear we don't have a record of what was said. Yes, something was explained to Mr. Botto, but if trial counsel failed to explain to him specifically, there are disadvantages. There are some real problems with asking for a mistrial. The state may get Williams rule witnesses. The state may get child hearsay. That's something that had to be explained to my client for him to make a knowing, intelligent, and voluntary decision regarding this. One last point I wanted to make, Your Honor, you asked about did I raise the child hearsay issue in the briefs. I gave you the pages for that. It's also alleged specifically in the post-conviction motion at pages 40 and 41. So I would ask this court to reverse on the first issue and at the very least remand for a hearing on the second and third claims that we discussed. Thank you.
All right, counsel, thank you both. That'll conclude this argument, and we'll be in recess until 10 o'clock this morning. Thank you both. Have a great day.
You too. Thank you, Your Honor.